Hi, everyone. Welcome to Crime in Court. This is the final part of Jamie Pisarcik's testimony, who is the ex-girlfriend of Lyle Menendez, in the case of California versus Erik and Lyle Menendez. We are watching, or we are reading through, because we don't have camera or video. Unfortunately, there were no cameras in the courtroom, so we only have the transcript. We are reading through the transcript of the 1996 Menendez brothers trial. This is their second trial. The first one ended in a mistrial in 1993, and their second trial ended in a conviction, life without the possibility of parole. As you may or may not already know, they have a currently they have a motion for resentencing that is being fought very hard by the DA, the new DA that just came in last December into office, and it's been a big fight. Today, as you're watching this, is actually the day of the hearing for the motion to recuse Nathan Hochman, the current DA, to take him off the case because he's shown a whole lot of bias and wanting to keep the brothers incarcerated forever. So that's kind of where we are in this case. But we are reviewing the trial because we can learn so much. And back in 1993, it wasn't discussed. The abuse of uh, adult males on their young male children, it wasn't really talked about. It was shunned. It was made fun of. It was not something that everybody took seriously. Now we take it more seriously, but back in 1993, we did not. In 1996, we didn't. The public didn't understand. There was this misunderstanding by the general public of what abuse was, of how it affected people, and how people in a severely traumatic situation might react. So we're looking at it in that lens as we read through the transcript. So without further ado, let us begin. I am going to shrink myself here and get us started. We left off on the very long cross-examination of Jamie Pisarcik, girlfriend at the time of incarceration, at the time of when he was arrested, or right before the homicides of their parents. They were on and off again, let's say. So she is now about to begin redirect with Ms. Nahara asking questions. So let's get started. And we were still in the state's case. This is Miss Nahara is for the state. And you can see on the screen, I have images of all the key players that are talking besides the witnesses, the judge and the attorneys. All right. Ms. Nahara says, "Good morning, Ms. Pisarcik." Good morning. Ms. Pisarcik, yesterday you were asked about some contacts that you had with the defense in this case, the previous defense attorneys and the previous prosecutors. Do you recall that? Yes. Now, the first time that you were contacted by anyone in this case, who was it who contacted you first? That would have been Jill Lansing with the letter. In this letter, I believe you testified yesterday that it came sometime around September 25th, 1992. Is that correct? Correct. And there was an exhibit 162. Is that right? Showing you exhibit 162. Is that what we're talking about? Yes, it is. Now, you wrote back to her on October 11th, 1992. Is that right? Correct. And that would be the letter that's been marked 163. Is that right? Yes, it is. So let's see. Less than a month after you got the letter, you contacted her and stated that you did not want to be involved in this case. Is that right? That is correct. And was that your feeling at the time that you did not want to be involved in this case? Yes, it was. About 17 days later, on October 28th, 1992, were you contacted by the former prosecutors in this case? Yes, I was. Now, was that the first time you had ever been contacted by the prosecutor side of the case? Yes, it was. And at that meeting, did you want to be involved in this case? No, I did not. Did you tell them anything to that effect? Yes, I did. And what did you tell them? They showed up unannounced at my front door. I answered the front door and then they started to ask a few questions. And at that time, I may have answered the questions, but I also stated that I did not want to be involved in this and that I would like to seek counsel and talk to an attorney to find out what my rights were since I had not been contacted in years, by anybody, and that I didn't know if I had to speak to them or not. So this all started in September, and by October, you'd been contacted by both parties? Correct. And you had told both parties that you didn't want to be involved? That's correct. Now, did something happen at that meeting that forced you to be involved in this case? Well, they said I would be subpoenaed. And you were subpoenaed. Yes, I was. And were you subpoenaed to come to the DA's office on November 30th, 1992, and give a statement? Yes, I was. And is that the reason that you gave that statement? Yes. And that was because you were under court order and you didn't want to go against the law. Correct. Now, you've been asked some questions about that previous statement the other day. Do you recall that on cross examination? Yes. Now you're going back to what was discussed on now going back to what was discussed on that statement. That was the first real conversation that you had with anybody. Was that the November 30th statement? That's correct. So this is November 30th, 1992? Correct. Now, back in 1992, when you were put under oath and asked questions, were you asked about the statement that Lyle Menendez made to you in the jail where he told you that he had taken his parents' lives? Yes. And back then, did the prosecutors that basically uh and back then, did you tell the prosecutors that basically in December of 1990 he wrote, and you were in the witness area of the LA County Jail, and he held that up. He said that he had taken his parents' lives, that he had taken his parents' lives. Yes, that is correct. And you said that back in November of 92? Yes. And back in November of 92, when you first had the first big statement that you gave about this case, did you say at any time or at that time that it was a letter and it was very apologetic and basically he said he was sorry because he hadn't told you this before? Yes, that's correct. And you had believed in his total innocence? Yes. And that is why it was very apologetic? Yes. And all of this was stated as a result of your being subpoenaed in to give this statement. That is correct. Now, back in November of 1992, did you also state that the defendant, Lyle Menendez, had told you back at the beginning about the mob or the mafia? Yes, I did. And this was in that statement that you made way back in November. Correct. Now, back when you spoke to the prosecutors in November, was Detective Zoller there as well? Yeah, he was. Now, did you tell them back in November 92 for the first time that previous to telling you that he had taken his parents' lives, that he had asked you, that he had told you that he was working on his own defense type of thing? Objection, leading, sustained. Did he tell you something about working on his own defense? Yes, he did. And did you tell that to the prosecutors back in 92? Yes, I think I did. And with regards to what you had testified to previously, that the defendant, Lyle Menendez, had asked you to watch the movie at close range, watch the scene where there was a scene where the father attacked a son's daughter. Did you tell prosecutors back then that he asked you to watch that? Yes. It was the son's girlfriend, though. Okay, so back then, did you tell them that he had asked you to watch that and say that his father had tried to do that to you? Yes. And what was described in the scene? Or what was described in the scene? Yes. And all of that was a confusing question. And all of that was said at this first big interview in November. That's correct. And the scene that you were asked about yesterday in the movie, the scene that you described here in court, is that the only scene in that movie where the father basically comes on to the son's girlfriend? Objection, not within the personal knowledge of the witness. The court says, have you seen? Well, she says she's seen the movie, so objection overruled. The witness says, yes, I remember, yes. Okay. Ms. Nahara says, and the description that you gave yesterday in court, was that the description of the scene that you had seen? Correct. And that was an accurate description. Yes, it was. Remember, the prosecution showed this to her just before showed this particular scene that they're talking about, showed it to her while prepping the witness just before she goes on the stand. I think it was like a day or two before she goes on the stand. Now, when the defendant told you that he had taken his parents' lives, he also told you that he had been Mr. Levin. Says objection to the use of term using the M word. The court says your voice has changed again, Ms. Towery, because Ms. Towery is the one that is she's the one doing the cross, so she should be doing the objections, but she jokes and says, I'm a little hoarse today. The court says, was that your objection, Ms. Towery? She says, yes, that is. The court says, rephrase the question. Ms. Nahara says, when he told you that he had taken his parents' lives, he also told you that he had been abused. That's correct. And at that time, you testified you didn't believe him. Is that right? That's correct. And he told you that he had been SA'd. Is that right? Yes. And previously to that, that was when he had asked you to lie about his father essaying you. Is that right? That's correct. And you knew that that was a lie, and you believed that he was lying again when he told you about it, when he told you that he'd taken his parents' lives. Objection, compound, sustained. Also hearsay. Court says, well, it's also leading. Ms. Nahara says, okay, now he asked you to lie about the essay. Is that right? That is correct. When he told you he took his parents' lives and he told you about the abuse, he started to cry. Is that right? Yes. And we're not believing him why? And when you were with him that night before the memorial service in Princeton, he cried that night too, didn't he? Yes, he did. And he also lied to you that night about who took his parents' lives. That's right. Objection to the use of the term the M word. Also, lying is a conclusion on the part of the witness. So that is speculation. And yeah, the court says, rephrase the question, please. Objection sustained. The answer is stricken. Ms. Nahara says, the night before the memorial service at Princeton, you were with the defendant. Is that right? Yes. And he lied to you that night about who took his parents' lives. Same objection sustained. She's not supposed to use the M word because it implies that it was intentionally done at the hands of another with malice and all that. So you're not supposed to say that word. You say homicide, you say took their life, I guess you can say KI double L because that's what they're using instead. So she changes her question to say, did he tell you that he M'd his parents or that he KI double L'd his parents that night? She says, no, he did not. Did he tell you that he believed somebody else had taken his parents' lives that night? Yes, he did. Did you later determine that that was a lie. I feel like Maury. That, the lie detector says, that was a lie. She says yes. Ms. Tari says, objection, calls for hearsay. The court says, overruled. The answer will stand. So, yeah, this is terrible rulings by the court, I think. Ms. Nahara says, did he also cry that night when he told you these things? Yes, he did. And did you believe him that night when he was crying and he was lying? Yes. And then when he told you that he had been abused, he was crying again. Is that right? Yes, he was. And you had known that he had asked you to lie about the abuse before. Is that right? That's correct. And you didn't believe the lie then. Is that right? That's correct. Nothing further. Recross? And Ms. Towery does have some recross. All right, so she asks, Ms. Pisarcik, what you said in 1992 regarding Lyle Menendez's admission to you that he had taken his parents' lives, that was in 1992, wasn't it? Yes. And also what you said in 1992 about Lyle Menendez's request to you to testify falsely, that was true, wasn't it? Yes. And what you said in court about the scene in the movie, that wasn't what Lyle Menendez said to you, was it? Well, yes, it was. I mean, it was what he was asking me to do. He described that scene to you? He did not describe the scene. He asked me to watch the scene. And you didn't do it, did you? I had seen the movie previously. I didn't need to. And you said yesterday that Lyle Menendez never asked you to say that his father argued you. Isn't that right? He asked me to do what the father had done to the girlfriend in that scene, in the scene of the movie. He said, or he asked me if I knew what scene he was talking about. I knew what scene he was talking about. And you testified yesterday that Lyle Menendez never asked you to say that his father argued, didn't you? He asked me to do it. I thought in that movie that the girl was Ard, so that's what he was asking me to do. So, to say. Let me remind you again what you said in 1992, Miss Pisarcik. Ms. Nair says, object. If this is being used to refresh your memory, I think she can read it. Overruled. Ms. Towery says, question. What happened in At Close Range? Answer. I didn't. I had seen the movie before. I did not go home and watch it. I had not seen it. But in that movie, the father, I guess, makes passes, or I don't believe he R's the one character, the Sean Penn's girlfriend. He asked me to say that's what happened. Is that what you said in 1992? Yes, that's correct. And yesterday morning, before you testified, the prosecutor showed you a clip from what you believe is the movie At Close Range. Is that right? Yes. Oh, so it was the day of her testimony, the morning of her testimony. And you watched that clip that the prosecutor selected before you came into court to testify, didn't you? That's correct. And then you came into court and you testified as to what you had seen in that clip, didn't you? Yes, I did. So this could just be, I mean, Lyle could have been talking about something completely different, and we're just assuming that this is the clip because we don't know. There's no verification. But the prosecution is like, oh, well, this is going to be the clip that makes them look the worst, so we're going to use this clip. I mean, I don't know. I've never seen the movie. I have no idea. But it seems like they're really leaping to conclusions here. Anywho, now, you said that you came to or you went to the DA's office in 1992 to give that statement under oath, correct? That's correct. And you were subpoenaed to their office to give that statement. Yes, I was. You received a subpoena saying, come to the office of the district attorney. I was leaving my house in Marina del Rey and an officer pulled up with flashing lights behind me and subpoenaed me. Do you still have that subpoena? No, I don't. And was that subpoena in connection with the People versus Menendez? Yes, it was. And you were absolutely certain that you received a subpoena to go to the DA's office to give a statement. Is that correct? I was asked, well, when the policeman came up with flashing lights and came up and told me I had to appear at court. Yeah. So there's no subpoena, but they just came up and grabbed you off the street. And there's no question in your mind that you received a subpoena to go to the DA's office to give a statement under oath. Is that correct? Well, if it wasn't a subpoena, I don't know what it would have been, but I was called to come to court to give this statement. You were given a piece of paper with your name on it, correct? I believe I was, yeah. And it had People versus Menendez on it. Is that right? I don't remember what was said on it. Were you called to go to court or the DA's office? I was called to the office in Norwalk and give a sworn. Norwalk is, I believe, the office that they demote everybody to. That's where Pam Bazanich went after the 1993 trial, according to Mark Garagos, and also that is where Brock Lunsford, who is one of the attorneys in the DA's office recently who filed the resentencing motion for the brothers, he got booted to Norwalk. It's kind of like the walk of shame. You go there if you're being punished for something. The DA's office in Norwalk and gave a sworn statement. On a specific day? I believe so, yes. And to give a sworn statement in the DA's office, is that right? I believe so. Do you know so? Well, it was quite a long time ago, and I was very surprised when somebody came up behind me with flashing lights. So it was, you just testified that you received a subpoena to go to the DA's office to give a sworn statement. Are you now not sure? Well, I was asked to come down, and I do not have the subpoena, obviously, now, but I was asked, so I'm assuming that was a subpoena. You were saying you were asked by the policeman? I'm assuming it was a subpoena. You were given a piece of paper, is that right? I believe so, yes. And it had your name on it, right? I believe it did. And it had a date, correct? I think so. And a time, is that right? Again, I don't recall. Well, how did you know where to go? I'm assuming there was an address or something on there. I don't know. And you went to the address that was on the subpoena, correct? Yes. And that was the DA's office, correct? Yes. And the case that you were subpoenaed on was People versus Menendez, correct? The only case I've ever been on, I've been subpoenaed in, yes. I'm not asking you about your being asked. Your testimony was you were ordered by a subpoena to give a sworn statement. Is that correct? That's as I understood it, yes. Thank you. Now, may I approach, Your Honor? Yes. Now, in terms of these conversations that you had, let's see, where is that? In terms of the conversations that you had with Lyle Menendez while he was in jail, I just want to make sure that we have the date correct and the order correct. He was arrested in March of 1990. Is that right? Correct. Okay. And then he gave you a ring around Sweetest Day in October. Is that right? I believe that to be accurate, yes. Did you say Sweetest Day was in October? Yes. And then he asked you to lie about his father making a pass at you in late November or early December. Is that right? I believe sometime to be around there, yes. And that was about the movie At Close Range. Correct. And he said that he told Joel that you wouldn't do it. Is that right? Yes. And Joel was his attorney at the time. Ms. Harris says, I'm going to object no foundation as to who Joel was. The court says, sustained. Ms. Towery says, then in late December, he admitted to you the truth. Is that right? At some point in December, all right, we'll just put December. And then in January of 91, you broke up with him. Is that right? Well, that's when I pretty much stopped going down there to see him. 91, Ms. Towery? Oh, I'm sorry. Thank you. Um, so it was, wait, what? I don't know. 91. That's what she said. January of 91 is when they broke up. I don't know. All right. So is that an accurate timeline in terms of the dates of those events? To the best of my memory, yes. Ms. Tari says, "Could I mark this, Your Honor, as Exhibit 164?" The court agrees. She says, "Thank you. May I have just a moment? I think I'm finished." She confers with m- Mr. Levin. Ms. Tari says, "Thank you. I have nothing further." The court says, "Any more redirect?" Ms. Nahara says, "Briefly, Your Honor. Thank you." Just to clear up one matter, Ms. Pisarcik, actually two. The first one is the statement made in November of 1990. You did not describe the scene at close range as quote unquote an R scene. Why is that? I think when I initially talked to the prosecutors, one, I was embarrassed about the situation being that it was R, and two, I had not seen the movie in a while, and although I knew exactly what it was talking about, I didn't remember in exact detail what the scene was. So she didn't remember the scene. Holy cow. She doesn't know. She didn't know. These prosecutors are feeding this crap to her. And the defendant had asked you to review the movie, is that right? He did. And secondly, you received a subpoena the day that Detective Zoller came out with Pamela Bazanich and Les Zoller, is that right? I do remember that, yes. Did you talk to a lawyer about whether or not you had to be involved in this case? Yes, as a matter of fact. Ms. Tari says, objection, motion to strike, non responsive. The court says everything after yes. Yesterday would be non-responsive. Yesterday, I think he means everything after yes. All right, so Ms. Nahara says, and after you spoke to a lawyer about your rights and whether or not you had to be involved in this case, did you basically let the lawyer handle any conversations with the prosecution? Ms. Towery says, objection, calls for hearsay, also a conclusion on the part of the witness. Overruled. The witness says, the lawyer did accompany me during that subpoena. Ms. Nahara continues, and did you empower the attorney to enter into any discussions on your behalf with the prosecution concerning your involvement with this case? Yes. And as far as you know, did he make any arrangements as to what your involvement would be and whether or not you had to be involved? Objection, calls for hearsay, also speculation on the part of the witness, sustained. Ms. Nahara says, I have nothing further. Anything else? Ms. Towery says, I have just a couple more questions, Your Honor, for the recross. Ms. Towery asks, what's the name of this attorney? Stephen Davis. And he accompanied you on the day that you were subpoenaed to the district attorney's office to give the sworn statement. Is that right? Yes, he did. And you said that you didn't describe the R scene when the prosecutors asked you in 1992 under oath because you were embarrassed? Well, I was slightly embarrassed to say that Lyle had asked me to say that his father R'd me. So when you said, Ms. Nahara says, excuse me, Your Honor, I don't believe she finished the answer. The court says, had you finished? The witness says, no. Ms. Towery says, motion to strike. Non-responsive. The question called for a yes or no. The court says, I think it called for a little more than that. You can finish your answer. Wow. The witness says, but as I stated before, at the time, not having viewed the movie the week before or at any time prior to that recent time, I didn't remember the exact detail. I did not feel comfortable to go into detail without having viewed the movie a day or two before. Okay. But that doesn't even have anything to do with anything. I mean it doesn't because what you would be telling them is that you were asked to recreate a scene in your testimony about something that was in this movie. Make it yours, make it your own, make it, say that Jose did it to you. But I lost my train of thought where I was going with that. Um, totally lost my train of thought. Oh, well, so her statement to the police at that time or to the prosecution at that time would be Lyle asked me to do A, B, and C. It doesn't have anything to do with the movie. Like she doesn't have to watch the movie to actually say that. So her logic is flawed. Anyways, Ms. Towery says, so when you said the prosecution under oath, I don't think that he R's her describing that scene, you were lying? No, I was a little unclear because I had not had time to review it. So she didn't review it before her testimony? Which was it? Were you embarrassed and not telling them, or did you not know? I wanted to be accurate. So you didn't lie to them. Ms. Nair says, I'm going to object, argumentative, overruled. Nice. Witness says, no, I did not. Ms. Towery says, you didn't fail to tell them about the R scene because you were embarrassed. That would be lying. I believe I used the word R when I said I don't believe it was R. Obviously, if you were there, the tone of my voice was somewhat unclear because I wanted to be accurate. Ms. Towery says, thank you. I have nothing further. Anything else? Ms. Nahara can't leave it alone. She says, just briefly. All right, she asks Ms. Pisarcik, and with regards to the scene and whether or not it depicted in our scene, was it always your understanding that Lyle Menendez wanted you to state under oath that his father SA'd you? Yes. Thank you. Nothing further. The court says anything else on that one question. Further cross-examination by Ms. Towery continues. Ay, ay, ay. This is like never ending. Ms. Towery asks, you said yesterday that Lyle Menendez never asked you to say that his father R'd you. He asked me to do what he asked me to do or to say what was done to the girl from the movie. Thank you. Nothing further. The court says, thank you. You may step down. You want this witness to remain on call. Ms. Towery says, yes, please. The court says, all right, you're excused today, but subject to being recalled. And just to remind the jury, as I stated to you before her testimony began, or at uh, before her testimony began, or at the time it began, the testimony of this witness presented to you, the witness, Ms. Pisarcik, that testimony that you heard is received only as to defendant Lyle Menendez and is to be considered by you only in the case of the people versus Lyle Menendez. She says, or he continues and says, all right, are the people ready with their next witness? Ms. Nahara says, Your Honor, may we have a moment? We have someone here. I just don't know whether or not they're physically present in the courthouse. Court says, in the courthouse? Ms. Nahara says, in the courthouse. Actually, I may have misspoke. Okay. I think we're going to get into argument for a minute here. So let's get ready for that. But first, the court says, let's take a recess, and when we know for sure, we'll have everybody out. Hopefully, it will be by 10 o'clock. Ms. Nahara says, okay. Recess is taken. The following proceedings were held in the open court outside the presence of the jury. The court says, the jury's not here. Something counsel wanted to discuss. Ms. Nahara says, yes, Your Honor. I was just, if I could just get the words out. Yes, Your Honor. I was just speaking with Mr. Gessler, and there was, with regards, would you step outside just a moment? She sends Marcy Eisenberg out of the courtroom. Ms. Nahara continues. Marcy Eisenberg, the court had previously ruled that the statement concerning the shower and the statement concerning shoes was admissible. There was a third statement which, quite frankly, has been overlooked, and it was testified to in the first trial. And what the testimony was in the first trial was that there was a second conversation besides the conversation concerning the shower, and the second conversation dealt with the defendant, Lyle Menendez, calling her and asking her with reference to a will that would happen if a will wasn't found, and that was in the transcript of page 22,894. And I was talking to Mr. Gessler about that because I told him I was going to ask the court if this could be admitted, and he said it had been stricken in the first trial, and I was looking at page 268, and the reference was the Lyle Menendez jury was admonished to disregard that reference to the will, but no reason given that we can find as to why, and I think there was a different fact situation than appears now. I think it is relevant to the evidence that's been presented in this trial, and I'd ask the court to allow us to elicit that statement. The court says, I have no recollection of it at all, quite frankly. I don't either. Um, Ms. Nahara says, okay. The court says, is there anything on the record as to why it was stricken? Mr. Gessler says, I believe that it came up upon cross-examination, Your Honor, and there had not been a proffer made of that and there should have been. Mr. Burt said to strike it, and you did, and the next day, I think it was the next day, that you told the jury to disregard what they had heard. I, like other counsel, have relied upon the offers of proof and the proffers given in this case, and there was no proffer of that particular statement this time at all. The proffer is that they would ask, and in fact, as late as this morning, when I asked Ms. Nahara about it, she said, yes, it was just two subjects, the information about the shower at the time of the shootings and I do not intend to go into a deep cross-examination as to number of phone calls and sequence. And the second thing was the reference to shoes in the limousine at the memorial service. Those two things only. She said it will be short and sweet, and I said fine. And until the recess here, that was the status of discovery and proffer, and I've relied upon that, obviously. The court says, well, I don't know exactly what was said. Is this in a report or just something that she blurted out during testimony, or how did that happen in the first trial? I don't recall. Ms. Nahara says that's how it happened in the first trial. There was no report. It wasn't elicited on direct. What happened was, in response to questions on cross-examination concerning when she heard the conversation involving the shower, to get the time sequence straight, she was explaining about these two conversations and which came first in the order. And and when he stated was that on line 22894, in response to a question, she said, quote, because the second phone conversation I had with Lyle was about the will. He asked me something about the will. He wanted to know what would happen if it wasn't found. He wouldn't have asked me that once the family arrived, he would have gone to them. Why ask me? Marcy Eisenberg, if you forgot, is one of the assistants or an assistant, I believe, of Jose. So she knew his business dealings and comings and goings and all that stuff. She probably knew his affairs and things like that too. He had affairs with other women. He was could have been banging her. I don't know. She continues, oh, Ms. Nahara continues, that's how she put the timing with regards to when he told her about the shower. The court says, okay, so Ms. Nahara says it was not a report. The court says could have been a non-responsive answer as to why it was stricken. Why is it only now that you've decided you want to offer it? Ms. Nahara says, in talking to her, this was a very small piece of evidence, Your Honor, and in talking to her right now and going over once again the sequence, and I should tell you, when we had spoken to her, Ms. Miha spoke to her, and I spoke to her, and this is the first time when she went through that, was asked on cross-examination that she put it in order in reference to the will. And I looked up the passage and found this and what the significance of this all was. The court says, so the only significance is to assist her in determining the order in which she had certain conversations. Ms. Nahara says, that was the significance of originally, though I realize now as I think about it and read it again, that there is significance to that, and that would be why we would offer it. Yeah, you just realized that. Get out of here. You're playing games with the defense, and that's what it is. You're hiding the ball on certain things, which is the significance that he's once again asked about the will. Given the way the testimony has been coming out in this trial, there is a real issue as to whether or not the defendant, Lyle Menendez, was looking for a will because he thought he was going to be in a will or he didn't think he was going to be in a will. I think the defense, what they've put forth is he didn't think he would be in a will. So it becomes significant now, and that is why we would like to proffer it. It isn't something new, it's something that's been around for a while. The court says, so is the defense's position as to whether or not the defendant was or did believe he was or was not in the will. It's not something new. It's something you knew about before the trial started. During the first trial, that was the defense position. So that is nothing new either. He's going to let this in now. I just guarantee it. He's changing his mind on things that he's overruling himself from the first trial, and that's what he continues to do. Ms. Nahara says, "That, Your Honor, it's just something, as I sit here, it's something I believe is relevant and I'd like to proffer. It's something they have discovery on." Court says, "Well, they really don't believe it, came out and then was retracted and never pursued. And I assume that if they wanted to, they could have interviewed her as well on that subject. And has she been cooperative?" Ms. Nahara says, "Yes, she's been available." Ms. Abramson says, "No, for them, maybe." Ms. Nahara says she's very cooperative. She was just talking and laughing with Mr. Gessler here right now. I believe she and Ms. Abramson have a very cordial relationship. That is not true. The court says she provided Mr. Gessler with good laughter. Ms. Nahara says she would talk to him right now if he wanted to talk to her. That isn't an issue. The court says, "I'm talking about before today, if they knew that this was something they wanted to bring out." Ms. Amerson says, "Of course. We're cordial. Why not be cordial with a witness? I have tried to talk to her 3 years ago to interview her. She refused to be interviewed. She's very cordial and friendly. We could talk about the weather or New York City, but we cannot talk about the case, and she refused to be interviewed. She stated she never wanted to be interviewed by the defense and didn't want us to call her, and we've respected that. She's never been willing to sit down and talk about any statements with us. Certainly, she's cordial, and I say hi in the hallway, and why not? I like her. She likes me, no problem. But she won't give us any information about the case, and I understand her feelings. She feels very strongly. She's very loyal to her former boss, Jose Menendez, and she doesn't want in any way to assist us, even by giving an interview." Ms. Towery says, "Just to add to that, Your Honor, when Mr. Gessler and I went to Princeton last year to interview witnesses, we also sought to interview Ms. Eisenberg. And I spoke to her on the phone, and she indicated to me also that she did not want to be interviewed and would not be interviewed. Again, she was very polite about it. She is very cordial, but she declined an interview with me as well last fall in Princeton." The court says, "Okay. So she would not have apparently cooperated with an interview if you had known. So so what would you have done in preparation then, Mr. Gessler, for that?" Mr. Gessler says, "My cross-examination would take totally different lines than I'm not prepared to do. In fact, my cross-examination is designed not to go into the sequence of calls and things like that as to when the shower occurred, and I'm not going into the potential bias she might have because of her long-term relationship as an employee of Mr. Menendez. I was simply going to zero in on the two subjects that are the subjects in which she's going to testify to. It would probably be a 5 minute or less cross examination. The idea of bringing in this will all of a sudden requires considerable effort in looking at all the times she did not say that the police all the times that she did not say that to the police officer during the times that she had time to do this. Total reworking of the cross examination. He's right because, or she's right because she's got to revamp all of her questioning and preparation for what was going to be going into. Ms. Abramson says, numerous sets of notes, Your Honor, of interviews with the witnesses. This does not appear in a single one of them, and some of these notes are hard to authenticate because some of them were Mr. Detective Zoller's, some of them are Ms. Bazanich's, and some of them are the witnesses. And just going through them all to show that she never mentioned it is a major project. Court says, again, what is the statement that she said to that the defendant made? Mr. Gessler says, the statement is supposed to be something about what would happen if a will wasn't found. The court says, when was that said, according to her? Ms. Nahir says, Your Honor, she stated that that was with regards to the day or two, placing both conversations Monday or Tuesday after the Sunday morning homicide. Mr. Gessler says the reason she's doing that is she's again speculating, saying he asked me something about a will. He wanted to know what would happen if it wasn't found. He wouldn't have asked me that once the family arrived. He would have gone to them. Why ask me? That's what she's using to date the conversation, which is total speculation. The court says, I understand that. What did she say when he asked that question? How did she respond? Mr. Gessler says, was there any further conversation? Ms. Nahara says, there's nothing further verified on the testimony. Court says, when you spoke to her, Ms. Nahara says, when I spoke to her, she said she really didn't know. She said it might take long. The court says, it might take long to probate, and you can ask her right now. She didn't really know. Basically, talk to her lawyer. Mr. Gessler says to ask her now the contents of the conversation that we believe never took place doesn't answer the failure of discovery, Your Honor. To show this never took place requires a much more detailed cross examination than I was led to believe I would have to do today. Court says, right. Ms. Nahara says, it is relevant to show his preoccupation with a will, and that's something that has been highlighted more in this trial than the first trial. I think we are dealing with a different fact pattern here. Ms. Abramson says, there being only one set of facts, however, the people choose to produce them. The shower conversation, which she's trying to place at the same time, she described it as a quiet throwaway conversation simply said in passing. So, to try to overemphasize something that she really doesn't have any recollection about and that she's simply using it to speculate on dating the throwaway conversation, I think under 352 it's not sufficiently reliable. Court says, well, 352 doesn't really relate to reliability of evidence. Ms. Amerson says it has to do with probative value, though, if you will, what its probative value is compared to its prejudice. The court says the probative value doesn't necessarily go to the weight of the evidence, but whether it proves anything. This is tied in. This is tied in with the testimony of the rights has relevance and probative value. The rights are the individuals who saw them the next day, who had a friend of theirs went to or played tennis with Erik, and they came to pick up the tennis rackets the next day and spoke with the brothers. It's just a question of what fairness it works, of what unfairness it works on the defense at this stage. I'm talking about the defense for Lyle Menendez, since it's only offered against him. To have this brought up at this stage when the defense has compared certain examination, obviously lawyers are equipped to respond to shifting circumstances and changing facts and surprises that occur during the course of a trial. And it's part of the skill of a lawyer is just to do that, to respond to such things. But at the same time, the part of the responsibility of counsel in a trial in providing this discovery, this is really not a discovery issue so much as an issue of notice. The discovery occurred during the witness's testimony in the first trial, but a question of notice and cooperation among counsel at the time of that trial could be done effectively and fairly. The preparation could be done to examine witnesses. What I would do is delay this witness's testimony about that particular reference. I don't see how I could foreclose or would be justified in foreclosing it if that goes to her recollection of the defendant's statement. But I'll certainly delay it to give time to counsel to prepare for response to it in cross-examination and go forward with the balance of her testimony today. I don't know how long it would take you to prepare for it. You'd have to review notes of the interviews. Mr. Gessler says, Your Honor, as Ms. Abramson says here, there are numerous notes of the interviews of the witnesses, so it will take longer than it might for some other witnesses. The court says, well, I'll give you until tomorrow to get ready for that. Whoa! Mr. Gessler says, I would need at least until tomorrow to do that. The court says, we can certainly start now. Mr. Gessler says, since this witness has only two other topics to talk about, I think it would be easier and more efficient if we used all three at once because the cross-examination then would tie into all three of the things rather than just the two things that were proffered. The court says, to that extent, also, it might give undue influence to one over the other if the people intend to pursue this because the people gave such late notice that this is something you wanted to bring out. You only decided on it during the recess this morning. If you want to pursue it, then the witness will have to testify tomorrow about everything. That's your call. Both district attorneys confer. Ms. Nahara says, Your Honor, may I have a moment? The court says, sure. Ms. Nahara says, thank you. The court says, you have another witness here. Mr. Khan says, who is also for the prosecution, says, Mr. Anderson. But Mr. Anderson is Brian Anderson, the uncle of the brothers. Not a friendly uncle either. He tried to sue them, tried to testify on behalf of the state to give the brothers the death penalty. So there's that. That was in the first trial. Or no, does it? I don't know. I don't remember which trial. I just know that he did that. All right. So Mr. Khan says, Mr. Anderson, but I think they want a hearing regarding Mr. Anderson. Ms. Abramson says, also, I believe the people have a deputy sheriff here with some records on the 459 motion that they filed. I don't know why they brought the witness, but court says no. He said he would. Well, we can do that. But how long is the hearing going to be, Mr. Anderson, then? On Mr. Anderson, then? Ms. Abramson says it depends on how many things we're going to hear for the first time. Court says, you have notes now of his interview with Detective Zoller prepared? Mr. Khan says yes. Ms. Amerson says, we have like 4 pages of notes, and it is not very clear from those notes. First of all, the notes are a little different than what Mr. Khan told me, I think, because it's not very clear who's saying what. Court says, wait a second, they're talking. So Ms. Amerson says, excuse me. The court says, wait until they've finished talking. Somebody's talking. Ms. Amerson says, certainly. Certainly. The court says, what is the people's position then on Ms. Eisenberg? Ms. Nahara says, we can call her tomorrow morning, Your Honor. Court says, what then do you want to do now with Mr. Anderson? You were saying you had 4 pages of notes. Ms. Abramson says, yes, Your Honor, we have 4 pages of notes with new topics that we've never heard of before. I don't know how much of this the people are offering. What is with all this new stuff that's never come in before? You're on a second trial. It shouldn't have this much new information. The court says, let's have the prosecution then underline or identify. You don't have to do it on the record, just do it in the same fashion so the lawyers know what it is that you want to bring out. Ms. Abramson says, my concern is statements that appear here in quotes that he is attributing now to these topics 6 years later to one of the defendants or the other, and also the statement of the conversation, what Mr. Khan told me I relayed to the court earlier. What appears in the notes is, well, let's see, the following quote. When looking for a will, he, Brian, told them, Erik and Lyle, in an assumptive way, while in Jose and Kitty's bedroom, that they were in the will. Jose and Kitty would want them to be their heirs. And then comes the following statement, unquoted and unattributed. We expect that you will help us with setting things up. Then the phrase, they never disputed being in the will. They talked to him in a way that they knew they were in the will. First of all, Your Honor, one of the problems I have with this kind of discovery coming in the middle of trial is that Carlos Peralt has already testified about these matters, and here's a sequence of events that we're hearing for the first time from Mr. Anderson that we could have established certain facts from Carlos Peralt had we known it was necessary in order to put this in context. That's a great point. Because you could have been talking to other witnesses, getting stuff out from other witnesses if you knew that this was coming in. Sorry, I'm trying to pause and I'm missing my button here. I just need to take a sip of water. Okay. He continues on. The court may recall Carlos Peralt testified that Carlos Menendez found the will when neither Mr. Peralt nor either of the defendants were at home. Carlos Peralt was called at the Bel Air Hotel and he and Lyle Menendez, not Erik, went to the house. He didn't remember Erik ever being at the house the day that the will was found. So I don't know if Mr. Anderson's going to claim when he's going to say this took place, this conversation that he's describing, and I don't like finding out about it after the first witness who testified on this subject has been on and off the stand and lives across the country because if I knew when he's claiming this took place, there would have been a way, perhaps, to use Mr. Baralt's testimony to illuminate that. But beyond that, since I don't know, and since I want to find out, and once I do find out, I still will need to investigate her impeachment because I don't believe this conversation ever happened. I know my client wasn't even alone around Mr. Anderson until later in the week. And we know the will was found on Wednesday before the hike over to Mr. Wright's, before the hike over to the safety deposit box. And I don't know when it was that Mr. Anderson is going to claim he had access to my client for this conversation when my client didn't seem to be around before the will was found. So, it creates a serious discovery problem. It also creates serious credibility problems. 6 years later, he's remembering this for the first time. He had an interview with these prosecutors in February of 1994. That basically was like, it's enormous. It was a family history, an 8-page typed single page police report interview in which none of this was mentioned. Nothing about this conversation, nothing about his being alone with them looking at a will. And that's true of some other things that appear in this report for the first time concerning some threatening. The court interrupts him and says, well, again, I wanted the prosecution to identify those things that he intends to bring out. Ms. Abramson says, fine, all right. The court says, rather than talking about things you don't like, let's find out what it is that he wants to bring out. Ms. Abramson says, it's not a matter of liking it, it it just doesn't seem appropriate in this case. The court says, I'm just responding to how you phrased it. You didn't like it. What I want to do is see what the prosecution wants to bring out first, not just taking in general, or talking in general, sorry. Mr. Khan says, yes, we'll be offering the statement of Lyle Menendez that appears on the first page of the notes, which is the statement that he made to the effect. Ms. Abramson says, why don't you highlight the page, Mr. Khan? Mr. Khan says, page one is page one. Ms. Abramson says, the court says, I don't have the report at all. Ms. Abramson says, the judge doesn't have the report. Mr. Khan says, may I approach? Ms. Abramson says, if it's highlighted, it makes a record. If it isn't, it doesn't. Would the court like a highlighter? The court says, I have one, although I could underline it too. That would work just as well. Ms. Abramson says, I bet you could. The court says, what is it that you wanted to use? Mr. Khan says, we would like to use the statement of Lyle Menendez at the time that he went to Randy Wright's home, and that statement appears on that first page more than halfway down the page. It begins with the note, Lyle, and there's a statement in quotation marks. Mrs. Abramson says, why don't you read that into the record, Your Honor? So there is a record. The court says, we don't have to do it right now. Mr. Khan says, on the second page, there's a statement by Erik Menendez. Mr. Anderson recalls that he had a conversation with Erik Menendez in which Erik Menendez was suggesting that perhaps the homicides had been done by the mafia because he had, in fact, been contacted by the mafia, and he relates to Brian Anderson a statement that he made to him, and that it is what appears in the second page, beginning with the word Erik. Ms. Abramson says, huh? Mr. Khan says, on the fifth line down, that episode is recounted, as well as the conversation that followed, where Mr. Anderson suggested that he should go to the police so that they can trace the phone call, and Erik Menendez backed off and said, never mind, I shouldn't have told you. So we would be offering the statement of Erik Menendez. Ms. Abramson says, well, Mr. Khan says, then there's the statement of Lyle Menendez that he made at the time that he went to the bank to look at the court says, you'll have to wait outside, Mr. Anderson. Mr. Anderson exited the room. Mr. Khan says at the time he went to the bank and went through the safety deposit box, he indicated that Lyle essentially repeated. Court says, what page? This is still on page 2. He begins talking about the safety deposit box being there at the bottom of the page, and that continues on down through the bottom of the page and continues over into the top half of page 3, and that episode ends with the line, same statement as the safe, and what he related to us there. And Lyle Menendez was saying the same thing that he said at the time they were wanted to go through the safe at the home, that he didn't want Mr. Anderson present at the time that the safe was open. Well, Mr. Anderson's not family. Like, why would you want him there anyways? And then in the fourth area, he would be getting into it. Also appears on page 3, picks up where I just left off. That is where it begins when looking for a will. He refers in those 2 paragraphs there to the occasion in which he had a conversation with both defendants, indicating his belief and expectation that they were in the will, and they responded affirmatively to that, indicating to him that Ms. Abramson cuts him off and says, "Where is it?" They responded affirmatively. Mr. Khan says, and that they would be seeking his help in regards to financial matters. I don't see that they responded affirmatively. Is there something left out? There's a brief pause in the proceedings. The court says, "That's what you intend to offer?" Mr. Khan says, "Yes. From the conversation that we had last night, yes." The court says, "Let's hear the response from the defense." Ms. Abramson says, "We object to these statements on these new topics coming in this late in the game, and I'm not prepared to examine the witness on this topic. My understanding was the witness was going to testify in accordance with previous statements concerning 3 things: the camcorder discussion in Kalamazoo, which was to be admissible only against Lyle Menendez, so I wasn't going to examine him at all. The trip to the safety deposit box and Mr. Wright's house, as appears on page 6 of the 8-page interview with the witness, which was conducted on February 22nd and February 23rd, 1994, which does not contain the quotations that he now remembers attributing these particular statements to Lyle Menendez. Those were the only things that he had any notice of that he was going to testify to, or any reason to believe he was going to testify to in the people's case in chief. So now we have new conversations by Lyle Menendez, which obviously should not be admitted against my client. And then we have this remarkable little chat about the mafia, which we have no idea when it took place, where it took place, what the reference, quote, Marta knew about it, unquote, means in the middle of that paragraph on page 2, nothing about this before. I can attest that Mr. Anderson certainly was aware of the mafia issue. In fact, Mr. Anderson called me the first year that I was representing Erik Menendez to pursue the mafia line. He was convinced the mafia did it. Wow, okay. That's interesting. Maybe he was the one pursuing that line. Why weren't we investigating the mafia, etc., etc.? So it's not a topic that escaped his notice, and here it shows up at 6 o'clock last night. We would object. It is too late for the people to keep rewriting the script of these witnesses, no matter what the inspiration, the witnesses themselves, or their animosity, or the fact that they're still suing people in probative lawsuits. Hint, hint, wink, wink. Brian Anderson is suing the brothers for the inheritance, none of which I was intending to go into because, and the court says, you had already gone into. Ms. Amerson says, I went into them in the first trial. The court says it was gone into with Mr. Baralt's cross-examination. Ms. Abramson says, I wasn't going to do a number on the witness because I didn't think there was anything the witness was going to say that mattered. The court says, well, you brought out impeaching evidence about his bias through Baralt. Ms. Abramson says, well, I was also trying to bring out something that had to do with Mr. Baralt, not so much that had to do with Mr. Anderson. In any event, every one of these are the statements that were not given to us previously, that they want to drop on us today after this interview. They've never had any difficulty getting this witness to come and talk to them and tell them whatever it is he knew. And we simply think it's unfair and inappropriate for them to be coming up with this stuff at this point. Court says, okay, Mr. Gessler. Same objections, Your Honor. Again, on this witness, I was prepared to cross-examine only on that issue of the camcorder that was proffered and the statements previously made about Randy Wright's garage. This whole statement about being in the will, expecting to be in the will, is of considerable importance and means further examination that must be done, not just looking through reports and things, but talking to other people who were involved, recontacting Carlos Peralt and other people so that we're prepared for cross-examination on the sequence of events, which until now had not has not had considerable importance. Where or what Brian Anderson was doing in the house had very little importance when talking to Carlos Peralt when he was in town or on the stand. In fact, Carlos Peralt wasn't even present when the will was found. And I think the sequence here becomes very important as to what he knows as to where Brian was and what Brian was doing during the various days that were here. The court says, didn't Mr. Anderson testify about this in the first trial, about being in the house and looking for a will? Mr. Gessler says, yes, he testified generally about looking for a will, but nothing towards these conversations. The court says, let me hear from the prosecution as to why these things are only being disclosed now. Mr. Khan says, well, we can't give it to the defense until we learn about it, and this is the first. First of all, so you're first learning about it at 6 p.m. at night, and you think that you should bring it into trial. Gotcha. First of all, as far as some of the statements are concerned, I think it was clear that we would be testifying, or that he would be testifying, for example, to conversations with the defendants at the time of they went to Randy Wright's house and went to the safety deposit box. I even mentioned that in my opening statement, based on what we have in the police reports that we reported to them a long time ago, that he was upset about the fact that he was not permitted to be present at the time that the safe was open and the safety deposit box was opened. That's contained in the police reports. All he did here was flesh out what he meant in the prior police report. You bring the witness in and you ask him, what specifically do you recall hearing? I know you told us about this previously, but what were your specific words? These are the specific words. So this is not new. This is just fleshing out something he already told us. The court says, I already made that observation before this hearing started earlier this morning that I thought that was something that was going to be brought up during his testimony. Mr. Khan says, right. Court says, from how the trial has proceeded so far. Ms. Abramson says, well, Your Honor. Court says, let's go on to some of these other conversations. Let me just say one thing. This was not testified to in the last trial. I have a summary of all the testimony. The court says, what wasn't? Miss Abramson says, nothing about looking for a will, safety deposit box, Randy Wright's garage, none of that was testified to. The court says, no. We learned in the hearing involving Mr. Wright that the police first discovered anything about Mr. Wright through a follow-up interview with Mr. Anderson after the first trial. That's how they found out about it. So it didn't come out in the first trial. Miss Abramson says, I know that. That's not true. They knew about it before that. The court says, I'm telling you what the evidence was that was presented to me, and that's what I concluded from the evidence, not what you believe. Wow. It's not the court's job to be the trier of fact or finder of fact. That's the jury. But he's already concluded what evidence is accurate and what's not, and he's just going to side with the prosecution? Okay. Emerson says, I have more discovery than the court does, but I think the issue is whether Mr. Anderson testified to this in the first trial. He definitely did not to any of this, and none of these conversations, these statements of either defendant concerning either being at Mr. Wright's house nor at the safety deposit box have ever been proffered in our litigation. All we know is that Mr. Wright said Mr. Anderson was at the house, and Mr. Anderson has said he went to Mr. Wright's house and he went to the bank, and that the defendants wanted to look first, and that's about it. No specific statements have ever been given attributable to either of them by this witness, so there is every bit of this hearsay or admission, depending upon who it's being introduced against, is new. I would like to show the court that we have what we have, which is I've highlighted. These are the 2 pages, Your Honor, in the court's case, if the court cares to see it, of the 8-page interview with Mr. Anderson from 1994. All he's ever said is there was an argument between Lyle, Erik, and Carlos Peralt and himself over who was going to be present when the safe was opened. That's as specific as it's ever gotten. I had those sections highlighted on those 2 pages. Court says, well, I accept that that's how it was in the report. I don't doubt that. But the prosecution's saying now we've interviewed the fellow further and we've gotten more detail. That happens. That often happens in trial. Where you get more information in a joint trial with one jury, it behooves them to figure out what statements against each defendant they're going to try to introduce before opening statement so we can deal with it. It's fine that Mr. Khan mentioned something about it, although I don't think he indicated which witness was going to testify about going to the safe or to the safety deposit box, and he's had 3 witnesses on this stand. It's fine that he can say something, but we need to know what the evidence is going to be so we can address it if we think we need to, we think we need to in our opening statement. And we did not have these statements to deal with, nor to deal with that. The court says that doesn't bar evidence from being developed during the course of the trial that you didn't have a chance to bring it up during opening statements. If that was true, the trial would be static and the whole outcome of the trial would be determined on opening statements. Ms. Abramson says it's not appropriate for the prosecution to lay back and elicit things at the last minute from witnesses and then present them. And this has been going on with every witness in this case, pretty much. Pretty much. She's not exaggerating that they just keep um, hiding things. And then at the last minute, they're like, oh, yeah, we're going to bring this in. And they didn't tell the defense. Or they just keep mixing up their witness list, and then the defense isn't prepared for that day. The court says if it is deliberate, done deliberately, with the prosecutors knowing in advance what additional information the witness has and not putting it in a police report or not putting it in their notes, it's a violation of the discovery rule. If they don't ask the question and don't know what the witness is going to say, then it's just sloppy work. Ms. Abramson says it's tactical. The court says if they don't know what the witness is going to say, it's hardly to their benefit to delay talking to them. Ms. Abramson says then they have hostile witnesses who have been increasingly more inventive, wait for the night before, go for the jugular, get what they want. So it's all the witnesses that are doing this? No, I don't think so. They have nothing to lose so long as the court allows them to present evidence immediately thereafter. They don't interview a week before because that gives the defense notice. They interview the night before, and maybe we can get something good and we can spring it on them. And that's what's been going on. That's exactly what's been going on. She's not wrong. The court says, I don't see that's occurring. Really? Every day, Judge, this has been going on. But he doesn't see it. He's got blinders on to what the prosecution is doing. He says they have witnesses coming from out of state. You can't interview them on a phone? Yeah, they answer the phone, Ms. Abramson says. Court says they are being interviewed when they arrive. That's normal when people are interviewed, that they're interviewed before they testify. And if there's additional information, it's being turned over, and the court has to balance the right of the opponent of the information or the evidence to prepare for it. At the same time, permit the proponent of the evidence to put on relevant evidence if they haven't violated any discovery rules or done things to work on an unfairness on the opposition. But don't you see they're doing these things on purpose so that they can go, uh, they're like just borderline under the rules. They're borderline, they're getting away with it because they're doing it the night before. So they're not violating these discovery rules according to the judge, and it just springs up on them. But every witness this is happening with, that's not fair. He says it's improper for the court to exclude relevant evidence solely because it wasn't discovered until the day before the witness testifies. I told you he's going to let all this in. If that were the rule, then, as I said, we really would have trials based on opening statements and nothing else. Ms. Amerson says, I'm not prepared to cross-examine this witness based on this information today, and I won't be prepared to do it tomorrow either. The court says, okay, first of all, let's go back to the statements that the prosecution has referred to that it intends to elicit from the witness. The reference to the safe and opening the safe and things of that nature. That was mentioned in the initial report of Detective Zoller as I recall it. I don't have my file involving Mr. Wright here, but it seems to me that there was some reference either in Detective Zoller's testimony or that's the report of Mr. Anderson that goes back to 1994. I agree with you, it is mentioned but not these specific statements. The court says, I don't know if I had the whole report. I just had the page that referred to that initially. I don't think I had the whole report. If I did, I didn't read it because I only read the part that related to the findings of the reference to the safe. Ms. Abramson says, that's the interview with Brian Anderson that you're holding right now, Your Honor. That's page 7 and 8 of that interview, or page 6 and 7 of that interview, which is February 22nd and 23rd, 2-day interview, 1994. I think you had only the submission for Mr. Wright, not the submission the court says that could be. It was the report referring to Mr. Wright, how he was found by the police. I've never seen this before. Ms. Amerson says, well, I'll show it to you so you can see the full breadth of the discovery that we were given. The court says, I understand that you haven't been provided with the details of this man's statements, and it does certainly create a situation where you have a right to prepare for it, and it certainly opens him up for impeachment as to whether it goes beyond that, and calls upon the court to exclude his testimony. That's a separate issue altogether, and that's an extreme sanction that you're asked being based upon what's been presented to me. Why is it that you didn't speak with him in more detail before yesterday, Mr. Khan? Mr. Khan says, well, Your Honor, as counsel pointed out, we interviewed him in 94, and what he gave us was as counsel referred to, an 8-page typed statement recounting the entire history of the Menendez family, including relatives and so on and so forth. We spent an enormous amount of time interviewing these witnesses. Counsel takes it for granted. She's been on the case for 5 years, that all of these facts are known to her. When we interviewed him, we were asking questions like who was Jose Menendez and what did he do for a living? We were finding out the basics about the case. Who was Joan Vandermolen? Who was Carlos Menendez? And how do they all fit into this? We asked him a million questions when we interviewed him in 94. He indicated that there was an argument at the time of the opening of the safe, and granted, we didn't ask him, well, tell us, recount it in detail, word for word, who said what. We didn't do that. There was an argument at the safe, and the substance of the argument was he was not to be present. The defendants wanted to be alone, and that was something I mentioned in my opening and heard no complaint from counsel. I also said in my opening statement that we'd be presenting evidence that he was also excluded from the time of the opening of the safety deposit box. Again, we heard no complaint from counsel. I mentioned that in my opening statement, and that's what he's going to testify to. Now, he's simply going to give us the exact words. When you bring a witness in and you're about to put a witness on the stand, you say, wow, tell us word for word what happened. And you invariably find out new information. I bet if we sat down with Mr. Anderson for another interview, we'd find out more things. Every time we sit down with a person who's out of town, and who knows a great deal about the defendants and the victims in this case, the more you spend time with these people, you get a wealth of information. If I could spend another 2 days with him, I'm sure we would have new statements. We did not delay this. We took an enormous amount of information from him when he interviewed in 94, and one of the key changes from the first trial was information that we obtained from him. For example, this whole business about going to Randy Wright's house. It was through Mr. Anderson that we learned about the whole episode. That was something that none of the attorneys knew. Ms. Nahara found out through interviewing this witness back in 94. So it was after the first trial. So that's why they didn't testify in the first trial, the Wrights. That's why they were new witnesses for this trial. As soon as we found out about it, it was in a report. It was turned over to counsel. And here we have a very significant new breakthrough, which we learned from the witness. So we obtained an enormous amount of information from this witness, and it's simply not the situation that we're holding off on getting back to that argument that, about what words were used, who said what first. It's not something we held off on. As far as the other two statements that are contained in the report, which is Erik Menendez talking about the mafia, I don't even think we asked that question last time. Sometime during the course of the conversation, he was just rambling on about something or other, and he just blurted that out. I didn't even think of asking him. Did Erik Menendez ever tell you that he thinks the mafia is responsible? We were just having dinner, and he's rattling on about things. So they eat dinner together? And then he said, then there was that time that Erik Menendez said something about a call from the mafia. And I said, well, tell us more about this. And that's how it came up. And so it wasn't like we were holding off till the last minute to tell about the mafia. It's just one of the things, the more time you spend with the witnesses, the more comes out. The same thing about the conversation with the concerning outside of the will, the defendant knowing or believing that they were cut off out of the will. This is something that has been the focus, our focus, particularly since Carlos Baralt testified. Carlos Baralt, once again, the court should be aware, was unwilling to talk to us. We went back to the East Coast. We wanted to talk to Carlos Baralt. Phone calls were made from New York. We received the word through Terry Baralt that he was unwilling to talk to us. So we had no idea what information we'd be getting from Carlos Baralt. And it was only now that he came out here to California that suddenly he said, okay, I'll sit down and talk to you. Meanwhile, his wife, Terry Baralt, who was not our witness, is still unwilling to talk to us. It was only when he sat down and talked to us that we got some information from him concerning whether or not the defendant believed they were in or out of the will. Mr. Anderson is now back in town. We sat down and covered it with him last night, and then he recalled, yes, I do recall there was an incident in which I sat down with the defendants and we did discuss the money from the will. So again, it's something that it's part of the evolving process of learning more about the case. We learned more about this case when we interviewed Mr. Anderson in 94. We learned even more about the case when we interviewed Carlos Baralt just a few weeks ago. So it's new information that we just can't turn over until we get it. Ms. Abramson says, we haven't heard of any discussions that Mr. Anderson has been unwilling to talk about since the 20th of last February. Court says, okay, again, it really begs the issue. It's not whether they could have talked to him, but whether or not, number one, they did talk to him about the subject and they didn't disclose it, or number two, they deliberately didn't talk about it, obtained some tactical advantage at this stage of the proceedings, and I don't find that either of those events occurred. Screw you, Judge. I accept the representations made by the prosecution. Oh, baloney. As to how these interviews occurred and the fact that they occurred now doesn't bar the introduction of the evidence. The only issues are whether or not there is an impediment to the introduction of the evidence or receipt of the evidence because of some legal obligation. Ms. Abramson says, well, I think there's another issue. The court says, other than discovery? Right, she says. Court says, and also whether or not the defense needs more time to prepare because of the late revelation of this information. Ms. Abramson says, well, on a relevancy basis, Your Honor, the mafia business here is so peculiar and bizarre, I fail to see its relevance. This is not a situation where Erik Menendez is telling Brian Anderson that the mafia took my parents' lives. We don't know when it took place, who was present, what prompted the statement, but we do know that there was plenty of publicity that the mafia was involved in the homicides. And we know that Brian Anderson is not friendly to the nephews. So why, he's suing them. So he might have an advantage to lie about that. And I mean, I can't even quite understand what's supposed to be said here. Erik is claiming at some point that there was a phone call that Martin knew about from someone claiming or pretending to be the mafia. That really is not necessarily inconsistent with the notion that Erik Menendez never claimed his parents were lives were taken by the mafia. Someone could have been making a joke or a prank, and all it is a message supposedly given on a phone. And then Brian asks him if he went to the police, and all Erik says is, well, never mind, I shouldn't have told you. I don't see how that is relevant to the notion that this is supposed to support, which is Erik's consciousness of guilt by lying and shifting the blame to the mafia. The court says, well, since this was a conversation over dinner and apparently, from what I understand, Mr. Khan didn't follow up on it, maybe he did, but the way he said it, he didn't. We can take testimony from Mr. Anderson on that particular conversation. I am so sorry about that. I think a dog walked by, and my dog did not like that. All right, we continue on. We can take testimony from Mr. Anderson on that particular conversation outside the presence of the jury, get more detail on exactly what he said and his recollection of it. Ms. Abramson says, well, that's fine for the discovery part, but that's not fine for the preparation part. The court says that has to do with the relevance issue. Ms. Abramson says the same issue with respect to looking for a will. This thing is characterized one way by Mr. Khan, and the notes read otherwise, and I would ask, the court says, I have no problem in taking some testimony of this witness since it has been disclosed at this stage and it's only contained in rough notes. It hasn't been fleshed out by Detective Zoller in a written report, and because of the lateness of its revelation, I would be willing to have some testimony taken outside the presence of the jury on these subjects. So we're going to have a voir dire. We can do that now, and it would probably be my impression to excuse. You have no other witnesses here other than Mr. Anderson. Is that right? Mr. Khan says that is correct. We do have the detective who worked on the Calabasas incidents. Court says, okay, we can perhaps arrange to get the jury to their lounge now until after lunch. So we can, the bailiff says, I didn't hear you, sir. Court says, get the jury to the lounge until after lunch and we'll take testimony from Mr. Anderson. As soon as the jury is gone, we'll have the hearing. In the interim, we can, while we're waiting, talk to the Calabasas material. Oh, okay. The jurors exit the jury room, the court says. Before we get to that, since we have apparently a witness here on the Calabasas burglary situation, we can deal with that. The people filed a motion for introduction of that evidence. It was filed on October 30th. It had been preceded by some oral discussions in court on the same subject in a general sense. I've read and considered the memorandum filed by the prosecution. I don't see the relevance of this evidence at this stage of the proceedings. It was admissible in the trial, in the first trial, because of the posture of the case, including the fact that Dr. Oziel was a witness in the trial in the people's case in chief. I can see that this is evidence that might well come out during cross-examination of the defendants, either or both if they testify, but I don't see it as something that could be brought out during the people's case in chief because I don't see how it connects to anything that is before the jury. So they want to bring the Calabasas the Calabasas incident is where they did the burglaries, the homes of the burglaries. So the cop who oversaw that case or something they have here, and the court is saying we can't get into that in the people's case. Maybe if it comes out more in the defense's case, but it's not relevant right now. He says it's just evidence of another criminal act or another criminal act committed by the defendants, but it's not connected to anything. I don't see how there's any relevance to it at this stage. So the court rules that it would not be admissible in the people's case in chief. If it's to be referred to during cross-examination, we can hold a hearing and discussion on that subject before we get to that stage. But I don't see it as admissible at this time. Ms. Amerson says, I would ask for an in limine hearing before my client even testifies, Your Honor, so we know the limits, because under the prior rules, this is a juvenile case and I don't think it qualifies. The court says, well, just my initial reaction is that it's something that is discussed, and as we said before, on the tape interview in the discussion between the defendants and Oziel, and Ms. Abramson says, well, my client doesn't discuss it. Lyle Menendez does. The court says, well, we've had that discussion already, but we can pursue it further. Ms. Abramson says, okay. Court says, but I see where there are vehicles in which the prosecution can seek its admission during the defense phase of the case. But at this stage, there's certainly nothing that connects it to anything. It really would not be admissible at this stage. All right, so let's then go to Mr. Anderson, and the people should call Mr. Anderson to testify about these issues that we've been discussing. Ms. Abramson says, I don't believe, just as a point of reference, that we ever received the notes that support this 8-page police report. I'd like to inquire whether Detective Zoller has them still. The court says, when he comes back, we can ask him. Mr. Khan says, I believe the witness is in the restroom, Your Honor. He'll be here momentarily. The court says we will take our short break then. When he comes back, let me know. A recess is taken, and we are going to, in the next episode, go over Brian Anderson's uh, voir dire, his testimony outside the presence of the jury to talk about these same issues that we've been talking about the will and opening the safe and the safety deposit box and those conversations. So we'll get more into that in the next episode next week. So thank you guys so much for watching. Please hit the like button on your way out. Make sure you are subscribed, and I will see you guys in the next one. Take care. Bye now.